You're at a bar with your friends and you have a brilliant idea. You grab a napkin and a pen and you write out your will. I leave everything to my best friend Bob. You sign it. You've just created a will, right? Wrong. You've just created a legal nightmare for your family. What about that note you scribbled in a notebook before you went into surgery? What about that email you sent to your kids telling them who gets what? People think they can create a valid will by just writing down their wishes. But in most cases, these handwritten, informal documents are not worth the paper they're on. Today, we're going to talk about why your DIY will is a disaster waiting to happen. And we'll look at the cautionary tale of Larry King's handwritten will. Welcome back. I'm Tua, your estate planning attorney. Everyone wants to save a buck, and it's tempting to think you can save a few $1,000s by writing your own will. But as the old saying goes, you get what you pay for. And when it comes to your life savings, a cheap DIY will can be the most expensive mistake you ever make. Let's talk about why. Every state has very strict, very specific requirements for what makes a will legally valid. And if you don't follow these rules to the letter, your will is invalid. It's as if you never existed. In most states, a will must be in writing, signed by you, witnessed by two people who are not beneficiaries. That's the bare minimum. And there are all sorts of other technicalities that you can trip you up. What if the witnesses don't sign and you're present? What if you're not of sound mind when you signed it? What if someone pressured you into signing it? These are the issues that get litigated in probate court for years, costing families hundreds of thousands of dollars in legal fees. Let's look at a real-world example. The estate of Larry King. When he died, he left behind a handwritten will that was a short note written on a single page that he said he wanted to leave his estate to be divided equally among his 5 children. He specifically left out his estranged wife. What followed was a long, public, and expensive court battle. His wife argued that the handwritten will was invalid. She claimed he was not of sound mind when he wrote it and that he was unduly influenced by one of his sons. The court ultimately upheld the handwritten will, but not before the family spent a fortune on legal fees and aired their dirty laundry in public. And this was a case where the handwritten will was actually upheld. In many cases, they are thrown out completely. Even if you manage to create a technically valid handwritten will, it's probably not a good one. A well-drafted will does more than just say who gets what. It also should nominate an executor, nominate a guardian for minor children, create trusts to protect assets for young or irresponsible beneficiaries, address potential tax issues, include a self-proving affidavit to make probate easier. Your napkin will isn't going to do any of that. It's a blunt instrument that's likely to create more problems than it solves. I know I'm a lawyer, so I'm biased, but this is one area of your life where you should not cut corners. The cost of a professionally drafted estate plan is a drop in the bucket compared to the cost of probate litigation. An experienced estate planning attorney will not only make sure your will is legally valid, but they will also help you create a comprehensive plan that addresses all of your unique family and financial circumstances. They will help you think through the what-ifs and create a plan that actually works in the real world. Don't be penny wise and pound foolish. Your family's future is too important to leave to a napkin will. Invest in a real estate plan. It's the best gift you can give to your loved ones. Thanks for watching.